Section 3. Protecting homeowners from financial strain. During the foreclosure process, understanding the financial impact of foreclosure is more than just the loss of a home. It is a financial event that can have long-lasting consequences for a homeowner. In addition to losing the property, borrowers may face credit damage, potential liability for unpaid debt, and difficulty securing future financing. Because of this, it is critical for real estate professionals to understand the legal and financial tools available to help reduce that burden. By guiding clients early, agents can often help minimize long-term damage and, in some cases, avoid foreclosure altogether. Deficiency judgments in Arizona anti-deficiency protection. One of the most significant financial risks in foreclosure is the possibility of a deficiency judgment. This occurs when the lender sells the property for less than the amount owed and then seeks to recover the remaining balance from the borrower. For example, if a homeowner owes $300,000 on a mortgage and the property sells at foreclosure for $240,000, the lender may attempt to collect the $60,000 difference. However, Arizona provides important protections through ARS, paragraph 33.8114G. This statute generally prevents lenders from pursuing deficiency judgments when the property is a single-family home or duplex on 2.5 acres or less and used as the borrower's primary residence. For instance, a homeowner in Mesa living in a standard single-family residence that goes through a trustee's sale would typically be protected from any remaining balance owed after the sale. Understanding this protection allows agents to reassure clients and reduce fear during the foreclosure process. Using bankruptcy as a temporary shield and restructuring tool. When foreclosure is imminent, bankruptcy may offer a temporary pause and, in some cases, a path forward. Filing for bankruptcy triggers an automatic stay, which immediately stops foreclosure proceedings and collection efforts. Under Chapter 7 bankruptcy, a homeowner may eliminate unsecured debts such as credit cards or medical bills, freeing up income. However, this option does not typically allow the borrower to catch up on missed mortgage payments. For example, a homeowner in Chandler overwhelmed with $50,000 in credit card debt may use Chapter 7 to discharge that obligation, but if they cannot resume mortgage payments, foreclosure may still occur. In contrast, Chapter 13 bankruptcy allows the borrower to create a repayment plan over 3 to 5 years. A homeowner who is $25,000 behind on their mortgage could repay that amount gradually while staying in the home, making this a more practical solution for those with a steady income. While bankruptcy can be effective, it should always be approached with legal guidance due to its complexity and long-term credit impact. Loan modifications and direct negotiation with lenders. Before foreclosure progresses too far, many homeowners have the opportunity to work directly with their lender to find a solution. Loan modifications are one of the most common tools used to make payments more manageable. This may involve lowering the interest rate, extending the loan term, or even adding missed payments to the back of the loan. For example, a homeowner in Gilbert with a $2,200 monthly payment may receive a modification that reduces the payment to $1,100, making it sustainable long-term. Debt negotiation is another option, where the borrower works with the lender to settle the debt for less than the full amount owed. While not always successful, these efforts demonstrate good faith and can sometimes prevent foreclosure or reduce financial exposure. Practical strategies for minimizing long-term financial damage. The key to reducing financial strain during foreclosure is early action and informed decision-making. Homeowners who ignore lender communication or delay seeking help often face more severe outcomes. In contrast, those who explore options such as anti-deficiency protections, bankruptcy, or loan modification early in the process tend to have better results. For real estate professionals, this is where true value is provided. By educating clients, recommending legal or financial professionals when appropriate, and understanding Arizona-specific protections, agents can help clients navigate foreclosure with greater confidence and less financial harm. Case law and disclosure duties in distressed sales. Disclosure obligations do not disappear in foreclosure or distressed situations. One of the most common misconceptions among agents and sellers is that disclosure obligations are reduced or eliminated when a property is in foreclosure or financial distress. This is not true. Under Arizona law, the duty to disclose material facts remains firmly in place regardless of the seller's financial situation. Whether a property is a traditional sale, short sale, or pre-foreclosure transaction, all known material defects that are not readily observable must still be disclosed to the buyer. Failure to do so can result in significant liability for both the seller and the real estate licensee. Hill v. Jones, 1986, duty to disclose material facts. The Arizona Court of Appeals case, Hill v. Jones, established a foundational principle in real estate disclosure law. Sellers have a duty to disclose facts that materially affect the value of the property and are not readily observable by the buyer. In this case, the seller failed to disclose prior termite damage, which was considered a material defect. The court ruled in favor of the buyer, emphasizing that silence or non-disclosure in the face of a known defect can constitute misrepresentation. In a distressed sale context, this principle becomes even more critical. For example, if a homeowner in pre-foreclosure knows that the roof has been leaking for months but chooses not to disclose it due to financial hardship, they may still be held liable after closing. Financial distress does not excuse non-disclosure. Jennings v. Lee, 1969, Broker's Duty to Disclose and Fiduciary Responsibility. In Jennings v. Lee, the Arizona Supreme Court reinforced that real estate brokers owe a fiduciary duty to their clients and must disclose material information that could impact the transaction. This duty includes not only information about the property itself, but also facts affecting the buyer's ability to perform or the overall transaction risk. In a foreclosure-related transaction, this could include situations where a buyer is attempting to purchase a distressed property but lacks the financial ability to close. If a broker becomes aware that the buyer may not be able to perform, the broker has a duty to disclose that information to protect the client. For instance, if a listing agent knows a buyer's financing is unstable in a short sale that requires strict lender approval timelines, failure to communicate that risk could expose the broker to liability. Applying case law to real-world distressed transactions. These cases make one thing clear: disclosure is not optional, and it does not change based on the type of transaction. In distressed sales, there are often more unknowns, more urgency, and more pressure on all parties. This increases the likelihood of mistakes. Real estate professionals must remain vigilant by ensuring that all known material facts are disclosed, recommending inspections, and encouraging clients to seek professional advice when necessary. By doing so, agents not only comply with the law, but also protect themselves and their clients from future disputes. Online discussion questions. 1. Why do disclosure obligations remain the same in a foreclosure or short sale transaction? Answer. Disclosure obligations are based on material facts affecting the property, not the seller's financial condition. Arizona case law, including Hill v. Jones, establishes that known material defects must be disclosed regardless of the circumstances of the sale. 2. How does Jennings v. Lee expand a broker's responsibility beyond just the property condition? Answer. Jennings v. Lee establishes that brokers have a fiduciary duty to disclose material information that could impact the transaction, including risks related to a buyer's ability to perform or complete the transaction. 3. What risks do agents face if they fail to properly disclose information in a distressed sale? Answer. Agents may face legal liability, disciplinary action under ARS, paragraph 32-2153, and potential civil lawsuits for misrepresentation or negligence if material facts are not disclosed.